Yes, good evening to everybody. Welcome to the today class of law of tort. And yesterday that I am dealing with the general defenses, and I covered up to the warranty not fit injuria. Please read what I posted on the screen. Anyone, unmute and read what I posted on the screen. Hurry up.
Good evening. General defenses under law of tort. Sir, I have short problem. I cannot read that section, sir, which is small.
But yesterday
General
the same
defense
thing I
tort.
posted. There are 8 general defenses are there. What are they? Though not in the sequence yet, please tell me. I told you what is the first one, what is the last one.
Defenses of torts.
The first one is
General defendants under law of tort.
The first general defense is I told 2 times at the time. The first one is, the last one is. Okay, now you write the rest of the other things 6 in any manner. And you repeat it also. But now you are not in a position to give the answer. The first one is, say pass on.
Pass on, sir.
Warranty not fit injuria. And the last one is?
General defenses torts.
The last one is? General defenses, last one I told yesterday. I repeated also, general defenses, last one. The last one is, say pass on if you don't know.
No pass on.
Statutory authority. I repeated
Pass on,
twice
sir.
or thrice. The first one is warranty not fit injuria. The last one is statutory authority. Of course, the other things, you know it better. One after another, you can deal it. Okay, now let us come to that, because had the knowledge about the same and knowing agreed to suffer harm, whether this maxim is applicable or not. Let us see the one of the case law. Can you read this case law? Anyone unmute and read this case law which I highlighted here? Can anyone unmute and read this case law which is highlighted on the screen? And I magnified also for your purpose. Yes?
Bowater versus Rowley Regis Corporation case.
Read.
In the case of Bowater versus Rowley Regis Corporation, a car driver was asked to drive a horse which, to the knowledge of both, was liable to bolt. The driver was not ready to take that horse out, but he did it just because his master asked to do so. The horse then bolted and the plaintiff suffered injuries. Here the plaintiff was entitled to recover.
Yes, means the maxim is applicable or not applicable? If the applicable, he is not going to get anything. Is not applicable means he is going to get anything. Now you tell me. Is it applicable or not applicable? If you don't know, say pass on. I will give the answer.
Pass on, sir. Pass on.
Don't waste the time. I have given you such a kavacha kundalam to you, armor to you. You can say pass on. I will give the answer. See, when the applicability is there, he is not going to get it, because he voluntarily undergone it. When the not applicability is there, then he will get it. Here, the plaintiff was entitled to recover. That means the maxim is not applicable over here. Having mere knowledge doesn't mean that he has given the consent. So, a person who drives the cart is called? A person who drives the cart is called pilot.
Car driver.
There is another name is there. What is that name? Yes.
Pilot.
Pilot means a person who drives the plane.
Aeroplane.
Yes. A provide what is wanted to need by someone something that in cater exclusively for the foreign tourist. No, that is not. So generally we say the carter, a person who drives a cart. A person who drives a cart on the road diverts is called a carter, C-A-R-T-E-R. What is that? What is that? C-A-R-T-E-R.
Carter.
Yes. Pilot means a person who drives the plane is called pilot. Then what about the ship? What about the ship? If you know it, you tell
Navigator.
me. If you don't know it, say pass on.
Navigator.
No. Commander.
Pass on, sir.
Commander.
Okay.
Yes.
Okay,
Now
sir.
let us see the Smith versus Baker. The plaintiff was an employer to work on a drill for the purpose of cutting the rocks. Some stones were being conveyed from one side to another using crane surpassing his head. He was busy at work and suddenly a stone fell on his head, causing injuries. The defendant were negligent as they did not inform him. The court held that mere knowledge of the risk does not mean that he has consented to the risk, so the defendant were liable for this. The maxim warranty not fit injuria did not apply. Did you get anything? Because I already posted on the screen and I read also. You know, stone quarry, stone crusher, where the big boulders will be made and cut into the small boulders. Then they will put it in the machine. Which size that you want concrete, it will come out. That is called a crusher, or another is what do you say in Telugu? Quarry, stone quarry. So there they will cut into pieces. That pieces will be used for the concrete, RCC, reinforced concrete cement, for your slabs, for the road. You will use it. So at the time when crane is carrying the boulders from the upper height, one side to the other side, but generally when the crane carries the boulders, they will whistle it. The whistle will come, siren. At the time, the people will come aside. If any boulder falls over there, it will not fall on their head. They come aside. But at the time, he was busy at work and suddenly a stone fell on his head, causing injury. The defendant were negligent as they did not inform him when the crane is going on because they did not whistle it. The court held that mere knowledge of risk does not mean that he has consented to risk, so the defendant were liable for this. That means the maximum warranty not fit injuria did not apply over there. Even though working at the quarry is a dangerous thing, because the cranes from one side to another side, they're carrying the big boulders. At the time, if any boulder will fall over there, then definitely the death is imminent or injury is imminent. But if the workman ignores the instruction of his employer, thereby suffering injury, in such a case the maxim applies. The point is, the maxim will apply at that instance. Suppose if a person who is working on the undermine, they will be given a special type of these shoes, boots, and which is having the metal at the
Tip of the shoe.
toes,
Front part of the shoe.
in the front part of the shoe. But one day I told you that thumb is a right, either right thumb or right thumb of the hand. But బొటన వేలుని ఏమనాలని నేను చెప్పిన ఒకసారి నేను లెగ్ సార్ బిగ్ టో సార్
Pass on, sir.
హెలక్స్ HALUX హెలక్స్ HALUX హెలక్స్ బొటన వేలు కాళ్ళది. Okay, now let us see the another case law, Dan versus Hamilton case law. Yes, anyone read the case law? But the same person should not read. I want a new voice I want to see. Not Joshua, not Deepa. Yes, a new voice. Sir, mere cheppandi sir, new voice edi. Andalu. Be Andalu. Unmute and read.
Sir, can we mimic a new voice, sir?
Yes, I want the new voice.
Can we mimic, sir?
Hamilton case law. New voice. A new person. Unmute and read.
In Dan versus
In Dan
Hamilton,
versus Hamilton,
a lady, even after knowing that the driver was drunk, chose to travel in the car instead of any other vehicle due to the negligent driving of the driver. An accident happened which resulted in the death of the driver and injuries to the passenger herself. The lady passenger brought an action for the injuries against the representatives of the driver uh, who pleaded the defense of the violent non-fit injuria, but the claim was rejected and the lady passenger was entitled to the get compensation.
Entitled.
Entitled to get compensation. This maximum was not
Not
considered.
maximum. Maxim.
Maximum was not considered in this case because the driver's intoxication level was not that high to make it obvious that taking a lift could be considered as
Consenting.
consenting to an obvious danger.
Obvious
Sorry, sir.
danger. Now, the lady passenger, she wants to hire a taxi, but the taxi man is fully drunken. But in spite of that, also, she sat in the taxi, and the taxi man, when he was driving, met with an accident. In accident, the driver, who is intoxicated, died, and the passenger, the lady passenger, got the injuries, and she filed a case against the representatives of the driver, and the driver's side, they took the maxim voluntary not fit injuria, because you know that the driver is drunken, but why did you sit in the same taxi? The answer has come to the court decided. Whenever a person driving the car on the taxi stand, that gives a sense that he is capable of driving it. That means he is not drunken state and he is having all that valid license, and moreover he should not have any ear problem or eye problem, and that man only should have to keep the taxi in the taxi stand. It is an impression that, it is a presumption that he is there having the license and is not taken any drugs, and he is having every object of him, means ear and eyes are in good condition. Then only, even though she had the knowledge that the taxi driver is drunken, but still he had the same taxi, but this maxim is not applicable to her, and she is going to get the compensation from the representatives of the driver. Of course, if the taxi is having the insurance, then the insurance company come to the rescue of the owner who is of the car. Is it clear?
yes, sir.
The decision was criticized on various grounds as the court did not consider contributory negligence. Whether when she knows that that fellow is drunken state, why he had the taxi? Because there is no other taxi would be there, and he had the same taxi because she wants to go to a particular place very immediately. There is no other alternative. Hence, the court we consider no contributory negligence while deciding the case, but the court's reason for not doing so is that it is not pleaded that why it was not considered. So naturally, one should have to bring to the notice of the court, because she knows that the driver was drunken, but in spite of that also she had the same taxi. But that is not raised over there, even though it raised also there. But generally the presumption would be there whenever the car is on the taxi stand, the car is worthy enough to ride. Number one, the person who is sitting on the steering is having the capacity to drive in a proper way. That is the presumption. Suppose if it is not in a mood of the driving, let him not keep the car in the taxi stand. Let him come down and park in the private place, so that the other people will not come at that place and ask you. They will go to the taxi stand. If they find one taxi, yes, definitely they will hire it, even though she knows that the driver is drunken. Is it clear?
Yes, sir.
Okay. What is the name of the case law?
Damon versus Hamilton.
Not Damon, Dan, D-A-N-N, Dan versus Hamilton. Okay, now the negligence of the defendant. In order to avail the defense, it is necessary that the defendant should not be negligent. If the plaintiff consents to some risk, then it is presumed that the defendant will not be liable. For example, when someone consents to a surgical operation and the same becomes unsuccessful, the plaintiff has no right to file a suit. If the same becomes unsuccessful due to the surgeon's negligence, then in such a cases, he will be entitled to claim compensation. Suppose the surgery is done. There is no mistake on the part of the surgeon. At that instance, but the patient died. Yes, now, could you say the surgery is not successful, hence the patient died? Answer, they say, if the death is caused because of the negligence of the doctor, at that instance we can say that yes, surgeon, the patient died because there is some negligence in the part of the surgeon. At that instance it may happen, but there is no such a part of it. Then if a person dies also, it is not in the hands of the
Surgeon.
ఈవెన్ సర్జన్ ఫస్ట్ ఓన్లీ సే అమ్మా నేనైతే సర్జరీ చేస్తా, ఓకే, బతకడం అనేది ఎంత ఛాన్స్ ఉంటుంది అంటే 5% ఉంటుందమ్మా, మరి చెయ్యాలనా వద్దా? ఎస్,
Yes, sir.
ఎవ్రీబడి సేస్ చెయ్యి సార్, దేవుని దయ ఉంటే అది బతికే, నూకలు ఉంటే బతుకుతాడు, నూకలు లేకుంటే
పోతాడు.
అది సంగతి. మరి నూకలు ఉన్నాయా లేవని ఎట్లా చేయాలా? ఆపరేషన్ చెయ్యాలా? ఉంటేమో he will survive.
Survive.
If it is
Not he'll die.
exhausted, he will say bye to this world. Yes, anyway should say bye to this world, but sooner or later only. But still the man is greedy. Okay, next case I read. New tone I want. New tone I want.
Can I read, sir?
No, let me, because you are not supposed to read. Another new person, not women.
Yes, sir. In Slater versus Clay Cross Company Limited, the plaintiff suffered injuries due to the negligent behavior of the defendant's servant while she was walking along a tunnel which was owned by the defendants. The company knew that the tunnel is used by the public and had instructed its drivers to give horns and drive slowly whenever they enter a tunnel, but the driver failed to do so. It was held that the defendants are liable for the accident.
ఇందులో what word that you did not understand? Which word you did not understand? Vijayalakshmi,
Sir,
which word you did not understand? Know the meaning of it. మీరు చదివిన పదాలల్లా ఏ పదము మీకు కష్టం ఉన్నది, దాని అర్థం తెలియదు అని అడిగాను.
sir,
ఎస్, ఎవరైతే కోర్టుకు పోతారో వాళ్ళను ప్లేంటిఫ్ అంటారు, ఎవరైతే దానికి జాబ్ ఇస్తారో వాళ్ళను డిఫెండెంట్ అంటారు. పర్సన్ హూ గాట్ ఇంజర్డ్ he will go to the court, that means he is a plaintiff who got the injury. The plaintiff suffered injuries. How he suffered injuries? Due to the negligent behavior of the defendant servant. Who is the defendant servant? Railway department. While she was walking along a tunnel. What is tunnel? What is tunnel?
It is
Tunnel.
round Swarangam, sir.
Swarangam, sir.
మీరు ఎప్పుడన్నా సొరంగంలోకి వెళ్ళి పోయినరా అండి? వేర్ ద ట్రాక్ ఇస్ దేర్.
సబ్వే స్వరంగం పోయినాం సార్. సబ్వే స్వరంగం నుంచి పోయినాం సార్.
సొరంగంలో ఏముంటుందంటే ఒకటి ఏ షెల్టర్ నికే ఉంటుంది. అంటే ఎప్పుడన్నా ట్రైన్ వచ్చింది అనుకోండి, అటు దిగి ఒక ఏమంటారంటే దాని సైడ్కి ఒక ప్లేస్లో దాగచ్చు అన్నారు. దాగచ్చు అంటే యూ కెన్ స్టే ఓవర్ దేర్. కొంచెం దూరంలో ఉంటాయి టన్నెళ్ళల్లో. ఈజ్ ద సేఫ్. దాన్ని ఏమంటారంటే సేఫ్టీ ప్లేసెస్. సో ఎవ్రీబడి నోస్ దట్ ఈస్ ఓన్లీ ద టన్నల్ వేర్ ద పీపుల్ యూస్ టు గో. ఇఫ్ దే డోంట్ యూజ్ ఇట్, నో, దే హ్యావ్ టు క్లైమ్ ఓవర్ ద hill and go from the around. So if the railway department knows that the people are using the tunnel, at the time when the train comes over there, generally they will whistle it. Number one. Number two, they go slow. If anybody is on the track, he reaches to a safe place in the guard. In the same way, manaku, did you observe any time bridge untadi chudandi, edi river midana gaaniyandi lekunte any bridge, a long bridge would be there. Even the people will walk on the bridge because there is no other to go. So in the every bridge, after some time, there is a safe place to be there adjacent the both the sides. So whenever the train comes over there, the people those who are using the tunnel or the bridge, they will go to the safe side and they will stand. Ante oka iddaru muguru nilabedochu akkada anta space untadi. Even if 4 members or 5 members also will stand over there and let the train will pass. After passing the train, then the people will use it. So the railway department knows that these people are using the tunnel. At that instance, whenever the driver would be there, he will make the slow, and later on he should have to make it fast. It doesn't matter. Those who are on the track would be there, rails would be there, they will come aside and they will stop at the safe side. I don't know how many people have gone to the Goa పోయినరా అంటే మీరు ఎప్పుడన్నా ట్రైన్లో? కాల్కా నుండి చిన్న ట్రైన్ అవుతుంది, అది ఏది మీటర్ గేజ్ అనరు, దాన్ని నారో గేజ్ అంటారు. నారో గేజ్ ట్రైన్ ఈజ్ దేర్ ఫ్రమ్ కాల్కా టు ద గోవా. హ్యావ్ యూ గాన్? సార్ మేము కరీంనగర్ వదిలిపెట్టిపోము సార్, మేము ఖమ్మం వదిలిపెట్టిపోము సార్.
సార్ మేము తెలంగాణ వదిలిపెట్టిపోము సార్.
Now the world is very small. Today you will be, the morning you will be here, and the lunch you will be somewhere other country. So
ఎస్ సార్, మన దగ్గర పైసలు ఉంటాయి.
have a big vision. So if you happen to go from Kalka to Goa, because I took at least 3 or 4 times to my students to the Goa, not only Goa, even Chandigarh, in New Delhi, Jalpaiguri, Darjeeling, Mussoorie, and all the hill stations that you have seen it, including the Shimla, not Goa. Goa kuda untayi anukodu poyetappudu, but Shimla lo chaala untayi tunnels, are many tunnels are there. Kalka to
సార్ మీరే స్పాన్సర్ చేశారా సార్?
Yes, I am the escort. I am the principal.
Sponsor.
I will sign it. Yes.
ఓకే సార్.
See, my sign is valid in the anywhere in the India. At the time I was the principal at Akhila Bharati College of Law from 1990 to 1999. So we went each year at least 2 times or 1 time used to send the people, students to the various places. So it is a Shimla where you have the many tunnels are there, many tunnels. Whenever the tunnel passes over there, now everybody cries, including the ladies and gents. Okay, now let us come to the point. So when the tunnel is there, where you have to go the slow manner. So whenever the tunnels are there, the driver will whistle it and it will go in slow. Of course, it is a narrow gauge, no, it will go very slow only. So at that instance, having the knowledge that these people are using the tunnel, at that instance, they would be held liable to pay the compensation. Who? Railway department. Even though they know the knowledge, but it is the voluntary not applicable over there. So limitation on the doctrine scope, the rescue cases law, this voluntary not fit injury is not applicable, and the Unfair Contract Terms Act 1977, that is the English Act, here also the voluntary not fit injury is not applicable. Let we see one of the cases that the Hayes versus Harvard. This is the rescue cases. Voluntary not fit injury is not applicable. Means the person who suffered will get the compensation. Anyone a new tone should have to read this Hayes versus Harvard case law. Yes, a new tone should have to read this case law. There are total 11 members are there. Pallavi, could you try? Ravi Kiran, you are muted because I could not see that you did not mute it. Mute.
In
Pallavi,
Hannes
read.
versus Harwood, the defendant's servant left two unattended horses in a public street. A boy threw a stone on the horses, due to which they bolted and created danger for a woman and other people on the road. So a constable came forward to protect them and suffered injuries while doing so. This being a rescue case, so the defense of voluntary non-fit injuria was not available and the defendants were held liable.
In all the rescue cases, this maxim is not available. What is the maxim?
Voluntary not fit injuria.
Warranty not fit injuria is the maxim. ఇది నేను ఎందుకు చెప్తున్నా మాటమాటిక్ అంటే మీరు చదవాలా, మీరు ఉచ్చరించాలా, అది గుర్తుకుంటుంది. లేకుంటే సత్యమా గుర్తుకుంటుంది. యూ షుడ్ నాట్ read, recite, review. This is only the method where you can remember the things. So the defendant servant, what he did, he will left two unattended horses. At the time, only horses were there. Is drawn. The horses drawn carts are there. So two horses will be tied to the cart, and is unattended. He kept it the owner and he went somewhere. So the boys are girls are less, but boys are చిలిపితనం. చెప్పండి ఇంగ్లీష్లో.
Crazy.
Crazy is a hard word. Naughty.
Sir, naughty.
The boys are very much naughty. Even sometimes girls are naughty also. The boys are naughty and threw a stone on the horses. అది కాదు, ద టైల్కి దానికి హెయిర్స్ ఉంటాయి, చూసారా అండి మీరు? పొడుగ్గుంటాయి హెయిర్స్. ఆ హెయిర్స్
Yes, sir.
ఆ హెయిర్స్ వాళ్ళు ఏం చేయాలి, తెప్పుతారు అంటే గుంజుస్తారు. అఫ్ కోర్స్ ద హార్స్ వుడ్ బి దేన్ ఇట్ విల్ కిక్ విత్ ద బ్యాక్ లెగ్స్. అది దేనికి ఉపయోగిస్తారంటే దాని అది చూడతారు చూడండి, ఏది కుయి 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 దానికి యూజ్ చేస్తారు. అది ఇట్స్ లైక్ ఎ టాయ్. దాన్ని ఏమనాలండి, దాన్ని పియానో కాదు, అది పియానో అన్నారు దాన్ని. దెర్ ఈస్ ఎ సెపరేట్ వర్డ్ ఈస్ దేర్. ఓకే, ఐ విల్ టెల్ యూ లేటర్. I will show you the figure also later part. So this boy, naughty boy, is throwing a stone on the horses, due to which they bolted and created danger for a woman. అయితే అది ఏం చేస్తాయండి, ఒక్కసారి మీరు వేసినాం అనుకోండి, ఇట్ ఫీల్ దట్ కార్టర్ ఈజ్ రెడీ అండ్ హీ వాంట్స్ టు మూవ్ ఇట్. నెంబర్ 1. నెంబర్ 2, అది ఏమైతుంది, ఒక్కసారి జనకిస్తుంది. ఏది జనకడం అంటే తెలుసా అండి?
భయపడ్డం సార్.
ద హార్స్ ఏమైందంటే ఒకసారి దాన్ని ప్రత్యేకంగా ఒక వర్డ్ ఉన్నది దానికి, స్టార్టిల్ అంటారు దాన్ని. STARTLED, స్టార్టిల్ అంటారు. ఇప్పుడు నేను చూపెడుతున్నాగండి. స్టార్టిల్ అంటే ఏంటిదంటే ఒక్కసారి ఏమవుతుంది, అది భయపడి ఏందనుకుంటే అది ఇట్ బికమ్స్
ఉలిక్కి పడుతుంది సార్.
స్టార్టిల్డ్. స్టార్టిల్డ్
ఉలిక్కి పడడం సార్.
అది సంగతి. A feeling or showing a sudden shock or alarm. Her startled eyes met his. Startled under them, especially STARTLD, because of the stone, the horse becomes startled and he got frightened and moved violently. The moved towards the public road. A public road was there. It is moved towards with a speed. Two horses. At that in the public road, there is a mother and a boy was standing on the public road. So a policeman saw from the police station, and this horse is running with the speed. So he came and he stopped the two horses with his hand. So a constable came forward, protected them. If not, the child and mother will be run over by this cart. So protect them and suffered injuries while stopping the horses. This being a rescue cases, then voluntary not fit injuria was not available. Then we should not say that who asked him to stop the horses, because it is a humanity. If he would not stop it, then the boy and the woman would be run over by the cart with that view, and he stopped it. And when he stopped it, he suffered the injuries. The injuries would be claimed from the defendant, that is the cart owner. Here, even though he came from the police station by saw, and voluntarily he came over there, but still he suffered. That is the reason in the rescue cases, this maxim is not applicable. He is rescuing whom?
Public and the people who are sitting in the cart.
Yeah, not people are not sitting in the cart. He is rescuing the people, those who are standing on the road, especially the boy,
Pedestrians.
a child and a mother.
Yes.
So he stopped the horses. While he was stopping the horses, he got injuries. So all the rescue cases, this maxim cannot be applied. So the defendant would be held liable to pay the compensation to the constable who suffered the injuries. However, if a person voluntarily attempts to stop horse, which creates no danger, then he will not get any remedy. Suppose if there is no imminent danger is there. సారు మొత్తం మైదానం సార్ మొత్తం మైదానం the ground. Okay, there is no imminent danger would be there. Now why he stopped the horses? There is no necessity. If there is a necessity is there, the imminent danger would be there. When he stops it, he will get it. There is no imminent danger would be there where the plain road is there. No money on the road is there. At that time, you need not to stop it. Is it clear? Is it
Yes,
clear?
sir.
సార్
Yes, sir.
బస్సులో పోతాన్నాం,
Yes,
ఓకే
sir.
పోతాన్నాం, ముందట ఒక అమ్మాయి ఉన్నది, ఓకే ఉన్నది, మంచి అమ్మాయి, ఓకే, వాడు బ్రేకే కొట్టలేదు, ఎవరు డ్రైవర్ బ్రేక్ కొట్టలేదు, అప్పుడే మీద పడతామండి సార్? కొడతాడని నేను పడ్డా సార్, కొడతానని పడ్డా తెలుసా? చెంప మీద
చెల్లు అనిపిస్తుంది.
చెల్లు అంటది చెంప. కొడతాడని కొడతావా నువ్వు అంటే యాంటిసిపేట్ చేస్తాను నా బ్రేక్ కొడతాడని. So when there is no such a thing, you are not
I can't hear you,
early
sir.
break there and you early you balance it out there, then you touch it, okay, that is a different issue. కానీ బ్రేక్ కొట్టముందే సార్ కొడతారని పడ్డా సార్ నేను. Okay, let us come to the point. Yeah? Don't do such an experiment. You know? So in the case of the Wagner versus International, name of the case la ఇప్పుడు చెప్పండి.
Wagner versus International Railway.
ఇందాక చెప్పినది కానిస్టేబుల్ రెస్క్యూ కేసులా ఏంటిది అది కేసు?
స్లాటర్ వర్సెస్
ఇప్పుడు చూడండి, హేన్స్ వర్సెస్ హార్వర్డ్ కేసులా నేమ్ ఈస్ హేన్స్ వర్సెస్ హార్వర్డ్ కేసులా, దట్ ఈస్. సో
స్లేటర్ వర్సెస్ క్లే క్రాస్.
నో హేన్స్ వర్సెస్ హార్వర్డ్ కేసులా ఇప్పుడు అంతా చెప్పింది నేను. 2 attended horses startled boy, mother, child, imminent danger, voluntary fit injury, rescue cases, Haynes versus Harwood case law. So Haynes versus Harwood case law means a boy is throwing the stone on the horses, 2 unattended horses, where the horse becomes startled, running violently towards the public road, and where the policeman saw the woman and the child was there on the road and he wants to save them, so he stopped the horses. Meanwhile rescuing the horses, that he got injured at that instance, and he will get the compensation because the voluntary not fit injury is not applicable over there when there is imminent danger. When there is no imminent danger, yes, he is not going to get it. So now let us see the Wagner versus International Railways. Wagner versus International Railways. Anyone can unmute, but a new tone I need. A new tone, because there are 11 members are there. Yes, new tone. Please read the case law, Wagner versus International Railway. Yes.
Shall I read, sir?
A new tone.
In the case of Wagner,
Joshua, you already did. Deepa already did. Sri Lakshmi already did. Vamana already did. This is the new one. Sir, we don't know how to mute. How to know? If you don't know, in your life you don't know. Try it. Mute and read. Sir, మేము తెలుగు మీడియం సార్. ఏం కాదు, నేను కూడా తెలుగు మీడియమే, బిఎస్సి ఎంపీసీ, కొత్తగూడెం కాలేజ్, శ్రీ రామచంద్ర ఆర్ట్స్ అండ్ సైన్స్ కాలేజ్. మరి మీరు మంచిగా మాట్లాడతాను కాదు సార్. ఇంగ్లీష్ ఎవరి అమ్మ సొమ్ము కాదు, అవ్వ సొమ్ము కాదు అది. No country belongs it. A person who wants to master it, and it is his language. Do you think that English is a Britishers' language?
no sir, we think it is American language.
No American language, no British language. Because your father is and mother is speaking English in the house, automatically you speak English in your house, and it becomes a mother tongue is your mother tongue is English. In the Nagaland, people will speak English. In the Kerala, people will speak English because their father will speak and mother will speak. All children will speak. They don't know other language except the English. Okay. Now,
Sir,
read.
a railway passenger was thrown out of a moving train due to the negligence of the defendants, one of his friend got down after the train stopped to look for his friend, but then he missed the footing as there was complete darkness and fell down from a bridge and suffered from suffer, suffered from some
Severe.
severe injuries. The
Severe
railway company was
injuries. Severe injuries.
severe injuries. The railway company was labeled as it was a rescue case.
The railway company is liable as it was a rescue case. In what happened in the Wagner versus International Railway, a railway passenger, he was thrown out of the moving train because he was starting the train, but the negligence of the defendant with the railway company, and he was fell down. ఒకటేసి జర్క్ ఇచ్చిన అనుకోండి బ్యాలెన్స్ తోటి కింద పడతారు అందుకోసం డోంట్ స్టాండ్ ఎట్ ద డోర్. Never stand at the door. If you stand at the door, please try to hold it. Sometimes if the jerk is more, even your holding will fall down. It will give the way and you will fall down over there. But don't stand on the door and the open door. Try to lock the doors. But anyway, this fellow fell down from the negligence of the railway. So his friend, when it stopped over there, it shoots off the platform. A train ఏమైందంటే ప్లాట్ఫామ్ దాటిపోయింది. అయితే ద నైట్ కాబట్టి ఈడేం చేసిండు దిగి అడుగుడి ఇక్కడ పడ్డడే చూద్దాం అన్నాడు. అది ఖచ్చితంగా బ్రిడ్జ్ మీద ఆగింది. ఆ డబ్బా మాత్రమే ద ఫ్రంట్ వన్, ఎస్పెషల్లీ ఫ్రంట్ వన్. సో ఇట్ ఈస్ ఆన్ ద బ్రిడ్జ్ దట్ ఫెలో విల్ ఫాల్ డౌన్. వాడు కాలు పెట్టగానే బ్రిడ్జ్కి వెళ్ళి కింద పడ్డాడు. జనరల్లీ బ్రిడ్జ్ కాడ ఏంటంటే దెర్ వుడ్ బి సమ్ సార్ట్ ఆఫ్ థింగ్స్ ఆర్ దేర్ naturally because people use it now. But anyway, that fellow fell down from there because it shoots off the platform and he got injured because it's the night time. Why he got down? To rescue his friend. In rescue cases, the voluntary non-injury is not applicable. రెండోది, a driver should not shoot off the platform that తీసుకుపోవద్దు driver. It's the negligence on the part of the driver. ప్లాట్ఫామ్ ఎంత ఉంటుందో అంతవరకే ఆపాలి. అక్కడ సార్ డబ్బాలు ఎక్కువ ఉన్నాయి సార్, ప్లాట్ఫామ్ తక్కువ ఉన్నాయి సార్, అక్కడ స్టాప్ ఇవ్వద్దు. ఆర్ యు ఫాలోయింగ్ మీ?
Yes, sir.
Yes, sir.
When the bogies are many, the platform is short, you should not supposed to give the halt place in that platform unless until the platform length will be increased. లాంగ్ డిస్టెన్స్ ట్రైన్లో 22 bogies ఉంటాయండి. డబుల్ ఇంజన్ ఉంటుంది. సార్ పవర్ఫుల్ ఇంజన్ అంటే ఒకటే సరిపోతుంది. అదర్వైజ్ డబుల్ ఇంజన్ ఉంటుంది. దేర్ వన్ ఇన్ ద ఫ్రంట్, వన్ ఇన్ ద బ్యాక్. Okay, that is the case law. In the rescue cases, it will not be applicable over there. Now, next case law is the Baker versus T. Hopkins and Sons. That is the case law. A new tone. Unmute and read a new tone. Unmute and read a new tone.
Baker versus T. Hopkins and Son. Due to the employee's negligence.
You already read once. Why don't you give the chance to other people? Sir, nobody is coming forward, sir. Okay, read.
Okay, sir. Due to the employee's negligence, a well of a petrol pump was filled with poisonous fumes. Dr. Baker was called to help, but he was restricted from entering the well as it was risky. He still went inside to save 2 workmen who were already stuck in the well. The doctor himself was overcome by the fumes and then he was taken to the hospital where he was declared dead. When a suit was filed against the defendants, they pleaded the defense of consent. The court held that in this case, the defense cannot be pleaded and the defendants thus were held liable.
Were
Held liable.
Were held liable.
Yes, sir.
So,
Yes, sir. Yes.
in this case, what happened? The employer's negligence would be there, as well as the petrol pump was filled with the poisonous fumes. A petrol pump in the poisonous fumes unnadi mottam lopata vello. So this doctor was called to help, but he was restricted. Please, doctor, there is a fumes are there which is poisonous. but he thought that the fumes cannot do anything to him. So with the dareness, actually he should have used the oxygen mask, that thing would be there. But he entered and tried to rescue the people, those who are in the well where the fumes are there. And he still went inside the save to workmen who are working over there, and he was stuck in the well. And the doctor himself was overcome by the fumes, and he could not breathe properly. But he has taken the thing that he can hold the breath and come out by pulling them, but he could not do so. He was taken to the hospital where he was declared dead, because the fumes are there. The fumes totally went into his bronchial, his lung system, then everything filled over there, and he could not breathe it properly, and finally he dead. Who doctor is dead. So when a suit was filed against the defendant, because defendant told that not to enter into it, but to rescue the two people, those who were stuck down in the well, and he went over there. They pleaded the defense of the consent. The doctor went with his own consent. No, doctor went not to his own consent. As for the humanity, he wants to save the other people too, those who were stuck in the well with the fumes. When the suit was filed against the defendant pleaded that the defense of the consent is given by the doctor, and in spite of our warning also, he went over there. The court held that in the case, the defense can't be pleaded, and the defendant thus were held liable. Even the doctor knows that, but still he warned, but he entered over there and he lost his life, but the defendant would be held liable because there is also a rescue case. If he creates a danger of B and he knows that the person C likely to come to the rescue B, then A will be held liable to both the B and C. Each one of them can bring an action for the same independently. So now any risk to be there. సార్ ఇల్లు కాలుతా ఉంటే ఓనర్ని కూడా లోపల పోనీయరు, తెలుసా అండి? తెలుసా తెలియదా? ఎవరిని పోనీయరు. ఎవరైనా డేర్ చేసి పోయినా కూడా వాడిని ఏం చేస్తారంటే కొడతారు, ఎందుకంటే వాడు సస్తాడు కదండి. అయితే కొందరు ఏం చేస్తారంటే, అయ్యా కొంతమంది ధాన్యం తీసుకొద్దామని పోతారు. వాడు తీసుకొద్దామని పోతాడా లేపుకొద్దామని పోతాడా? Are you following me?
Yes, sir.
ఇల్లు గాడి వాడు చెప్తే వీడు సమయాన్ని దాన్ని he wants to exploit the chance. సో మీరు ఎప్పటి వరకు పోవాలి అక్కడ? ఫైర్ బ్రిగేడ్ రానంత వరకు పోవచ్చు ఒకవేళ పోయినా కూడా. కానీ వన్స్ ద ఫైర్ బ్రిగేడ్ హ్యాస్ కమ్, యూ విల్ బి కాల్డ్ యాజ్ ఎ ట్రెస్పాసర్. కోప్ వర్సెస్ షార్ప్ అనే కేసులో నేను చెప్తా తర్వాత మీకు. యు ఆర్ ఎ ట్రెస్పాసర్. ఎందుకంటే మీకు ఏంద్ర ఇంటెన్షన్? సార్ మరి ఇల్లు కాలుతాను కాదు సార్, ధాన్యాన్ని కొంచెం నాకు తీసుకొద్దాం. అరే నువ్వు ఎందుకు పోతావురా? ఫైర్ బ్రిగేడ్ వాళ్ళు ఉన్నారు, వాళ్ళ దగ్గర అప్రాన్ ఉంటుంది, వాళ్ళ దగ్గర ఆల్ గాడ్గెట్స్ ఉంటాయి, వాళ్ళు ఫైర్లోకి వెళ్ళి నడుచుకుంటూ పోవచ్చు వాళ్ళు. ఆర్ యు ఫాలోయింగ్ మీ?
Yes,
Yes, sir.
Because they do have the gadgets like that. Fireproof gadgets are there. Even though they have the water pressure, so they will use it and they will go and they will try to extinguish the fire. Because they are expert in the fire extinguishing. While training untadi vazapta. The trained people are there. Are you following me?
Yes, sir.
Yes, sir.
Commandos at తెలుసా అండి? కమాండోస్ ఎట్లుంటారు? షార్ప్ షూటర్స్ ఉంటారు. వాడు కమాండో, వాడు రివాల్వర్ లేకున్నా కూడా ఒకటి కరాటేతో చేతులతో చంపుతాడు వాడు కమాండో. అంత ఉంటుంది పవర్ఫుల్ వాళ్ళకు. Because they are trained in that way. Only one punch, the fellow will be died. So they know where to give the punch, where to give the kick. Are you following me?
Yes, sir.
yes, sir.
Yes. So this is the case where the baker will going to get it, because even though he knows that there is a risk could be there. Then another case law would be there, that is the Hythe versus Greater Western Railway Company. The plaintiff got injured while saving the defendant's car from the fire, which occurred due to the negligence on the part of the defendant. The plaintiff act seemed to be reasonable and the defendant was held liable in this case. See, the fire brigade raledi ikkada chusindra andi. The plaintiff got injured while saving the defendant's cars from a fire, which occurred due to the negligence on the part of the defendant. Because of the defendant negligence that it is happened over there, and he wants to save the plaintiff's car. The plaintiff act seems to be reasonable because it's a rescue cases either to the person or to the property. The rescue cases either to the
Person or property.
or to the person or the property, doesn't matter. The plaintiff act seemed to be reasonable and the defendant was held liable in this case. ఈ అన్ఫైర్ కాంట్రాక్ట్ టర్మ్స్లలో ఇంగ్లాండ్లో ఉంటుంది, నెగ్లిజెన్స్ పార్ట్ ఉన్నది అనుకోండి, ఇక్కడ ఇది అప్లికబుల్ కాదు. కొన్ని అన్ఫైర్ ట్రేడ్ ప్రాక్టీస్ అంటే ఉంది అంటారు. సైకిల్స్ ఆర్ కెప్ట్ ఇట్ ద ఓనర్స్ రిస్క్ అని రాసి ఉంటుంది, చూసిండ్రా అండి? హోటళ్లలో
Don't know, sir.
సైకిల్స్ ఆర్ కెప్ట్ ఇట్ ద ఓనర్ రిస్క్.
Never seen, sir.
ఓకే, వాడు ఏం చేస్తాడు, డిస్క్లైమర్ క్లాస్ పెడతాడు అక్కడ. మరి దుకాణం ఎందుకు పెట్టినావురా బాబు? నడుచుకున్న వాళ్ళు వచ్చిన వాళ్ళు లోపల తినాలనా? కార్లు వచ్చినోడు వేర్ యూ టు ఈట్? విత్ ద బైస్కిల్ ఇస్ దర్ వేర్ యూ టు ఈట్? ఇట్ ఈస్ యూ హ్యావ్ టు టేక్ ద కేర్ ఆఫ్ ఇట్. అక్కడ వాచ్మెన్ పెట్టాలను. ఆర్ యూ ఫాలోయింగ్ మీ?
Yes, sir.
Yes.
If you want, you can take some amount also. అమౌంట్ తీసుకుంటే ఇంకొకటి రాడండి, మాల్లో ఫ్రీగా వేయాలి పార్కింగ్. మాల్లో మీరు పైసలు తీసుకుంటారా అండి కారు పెడితే? సూపర్ మార్కెట్లో పైసలు తీసుకుంటారా?
Sir, వినబడలేదు సార్.
సూపర్ మార్కెట్, when you want to park the car, could the man will charge you for parking fee?
No, sir.
No, sir, he will not.
No, because you are an invitee. You do the business with them and you make the benefit with them, and it is there, they have to take care of you. Even they are not supposed to keep the floor wet. If the wet floor is there, they have to keep the caution board, the floor is wet, because you are the benefit, you are going to make the benefit to the supermarket, so you are an invitee, so more care should be taken to you. Are you following me?
Yes, sir.
Yes, sir.
సార్ వాడు కొందానికి వచ్చిండా సార్? విండో షాపింగ్కి వచ్చింది సార్. విండో షాపింగ్ తెలుసా అండి?
Yes, sir.
కొనకుండా చూసి వెళ్ళిపోవడం అనుకుంటా సార్.
బాస్ వాడు విండో షాపింగ్కి వచ్చింది కాదు, లైటింగ్ కొట్టడానికి వచ్చిండు పొలాలకు. సో దట్ వాస్ ద థింగ్ వుడ్ బి దేర్. వాట్ ఎవర్ మే బి దేర్, బట్ ఇఫ్ హీ ఫాల్స్ డౌన్ అండ్ హీ విల్ బి held responsible. Who? The owner is held responsible. Means the mall owner would be held responsible if the floor is wet. Is it clear?
ఎస్ సార్.
నెంబర్ 1. నెంబర్ 2, మీరు ల్యాండ్రీకి ఇస్తారు బట్టలు, అందులో రాసి ఉంటుంది బట్టలు చినుకుతే మేము రెస్పాన్సిబుల్ కాదు, బట్టలు స్టోలన్ అయితే మేము రెస్పాన్సిబుల్ కాదు అని రాసి ఉంటుంది చిన్న చిట్టీలో వెనకాల. అది కూడా భూతద్దం పెడితే కనబడుతుంది అది. స్టిల్ he cannot exempt from the liability. సపోజ్ యువర్ క్లోత్స్ ఆర్ లాస్ట్, ఇట్ ఈస్ యూ హాస్ టు పే. ఎందుకంటే బెయిల్మెంట్ అంటారు దాన్ని, కాంట్రాక్ట్లో ఏమంటారు? బెయిల్మెంట్ అంటారు కాంట్రాక్ట్లో. So when I give the money, you did the service charges, you take the service charges and give them back my clothes, but not on clothes.
Sorry, sir.
But not. So unfair trade practices లో మాత్రం ఇది వర్తించదు, ఎందుకంటే అన్ట్రేడ్ ట్రేడ్ ప్రాక్టీస్ అంటారు దానికి. So voluntary not fit injury is a complete defense, but the defense of the contributory negligence came after the passing of the law reforms Contributory Negligence Act of 1945. అయితే కంట్రిబ్యూటరీ నెగ్లిజెన్స్ అనేది ఒకటి పాస్ అయింది 1945లో. నౌ వెనెవర్ యువర్ ఇంజురీ ఈస్ కాజ్డ్ ఓవర్ దేర్, హౌ మచ్ ద పర్సెంటేజ్ ఆఫ్ యువర్ కాంట్రిబ్యూషన్ ఈస్ దేర్, దే విల్ కౌంట్ ఇట్. ఇప్పుడు మీరు హెల్మెట్ లేకుండా బండి నడిపిన అనుకోండి, 230 రూపాయలు ఫైన్